Welcome back. I must apologize. I appreciate that we're running behind time, but these have been really excellent discussions. So I'd like to welcome Merci Beaucoup, who is going to take the first presentation in our next session. Merci, are you around?
Yes, I'm very much here.
Fantastic. Do you have slides that you'd like to share there?
Yes,
or you not?
Yes, I will.
Okay, fantastic. Just before you start, so each of the speakers, there are some speakers who are speaking together. Each presentation will have a strict 15 minutes. And I will let you know just when you're about 2-3 minutes before the end of your presentation. Thank you.
So thank you very much once again. It's a privilege and a pleasure for me to once again be presenting and participating in a GSDEC forum. Interestingly, I'm just about to embark on a project for Transparency International, where we'll be mapping illicit financial flows from corruption across selected countries in Africa. Hopefully, I'll be able to present that report at some stage once we're through with it. So this conference is actually coming at a great time for me. Okay, so I'll be talking about following the money and corruption trends in East Africa. Because of the limited time, I will possibly just give an overview. I won't really delve into any case studies. I'll just talk about an overview of the trends and also the risk factors. Without further ado, I just want to start with this slide, which talks about 11 world leaders having fallen due to corruption since 2016. And I'm sure we can all guess where most of those leaders would have come from. But in terms of actual action being taken against them, you'll find that this will most probably be either in the Asian or the European countries, and not necessarily Africa. So if we look at this statement by Transparency International about the effect of corruption in terms of the way it erodes trust and weakens democracy and hampers economic development, exacerbates inequality, poverty, social division, and environmental crisis. So these are issues we need to look at and really look at in depth. Even as we talk about the cases, we need to consider what are the implications to the economies of these countries. As Transparency International say, exposing corruption and holding the corrupt to account can only happen if we understand the way corruption works and the systems that enable it. So if you look at the definition of corruption in most of our legislation in East Africa, because we more or less have similar legislation. So we talk about dishonest or fraudulent conduct, abuse of entrusted power for private gain. If you look at our act, which we refer to as the ASECA in Kenya, corruption actually encompasses a wide array of offenses from bribery, fraud, embezzlement, etc. We also have related legislation. For example, in Kenya, we recently enacted the Bribery Act in recognition that the Anti-Corruption Act did not include offenses by the private sector. So the Bribery Act now includes the private sector. And of course, we have anti-money laundering legislation. We have public officer ethics, leadership integrity, where, for example, public officers are required to submit wealth declaration forms. Regulation on public procurement, public finance, beneficial ownership legislation. So all this legislation is actually available. So if you look at the global statistics, it is argued that actually more than $1 trillion is paid in bribes alone each year, as compared to the size of the world economy of over $30 trillion. And if you look at that map there, the people who are doing badly are those who are light purple, the countries that are doing badly. So unfortunately, most of us in Africa are squarely there in the light purple stage, in the light purple sections. The only country I can see there in East Africa really is Rwanda, who are doing well with dark purple. The rest of us really have a long way to go. And from the Transparency International Corruption Index, this is the country score for the last report that was for 2021. You can see Kenya ranked out 30, Southern Sudan 11%, Burundi 19%. Rwanda is doing very well at over 53%. Actually, Rwanda is over the 43% average. And in ranking, you can even see Southern Sudan is last at 180 over 180. And the rest of us are not doing well at all, apart from Rwanda again, 52 over 180. So that is Kenya's position. And if you go to the Corruption Perception Index, every country has this kind of chart. So I don't need to dwell on that. So how does corruption affect us in East Africa? It impacts both the public and private sector. It is in every sphere of life. We talk about grand and complex corruption, and it normally goes hand in hand with money laundering, especially through the property market. Because we have people buying properties in cash, building property, etc. So the typical examples are procurement fraud. We've had mention of election offenses, employment issues, for example, in job placements, promotions, and even transfers. Education, where we have exam irregularities, school placements, even with teacher transfers, bribes which are just made to avoid compliance with the law. I remember being stopped one time by a police woman, and I had a problem with my car. My screen was cracked slightly, and my driver's license was mutilated. And she told me, "Oh, you know, the fines are very, very high." I told her, "Give me a cheat." And then she asked me, "Are you a Christian?" And I responded, "Aren't we all Christians?" You see? So, you know, this is the kind of thing we're talking about. It pervades each and every aspect of our lives. So in Kenya, we have some of these big major scams, NYS, where lots of money were lost through the National Youth Service procurement, accounts being opened overnight and money being siphoned out of those accounts. So if you look at the vulnerabilities, why are we in East Africa vulnerable to corruption? So we have withheld services. You know, in order to get the service, it was the only way to get it through bribing. Services are delayed to speed up the service. Harassment by authorities to avoid problems. Of course, people just wanting to enrich themselves because the opportunity is there to steal public resources. A dishonest attitude to payment for services. You know, you don't want to pay even when you have the money. Public acceptance actually is really something we cannot get away from, because everybody expects that that a public officer or even a private somebody in a private institution is going to ask for something in order for you to get an advantage or a service. And then other factors which were not part of this Transparency International survey were poor remuneration of public servants, unemployment, competition for services and contracts, and then the lack of political goodwill. Tone at the top is so important. Lack of knowledge. So for example, where do I report? Corruption then being entrenched as a culture. And then again, the channel for the money for payment of these bribes. We have a wide prevalence of mobile money. It is fast and, you know, more or less anonymous. And you know, somebody will tell you just transfer to this number. And when you look at the name, it is not their name. So this is the way it happens. So corruption is actually linked to most of the major predicate offenses that have huge amounts or generate huge amounts of money. So if we look at world trafficking, drug trafficking, human trafficking, illegal smuggling of goods, piracy, etc. All these factors, if you look at the vulnerability factors, they are all the same. Corruption, well-organized criminal syndicates, which also involve corruption and payoffs, the length of and porosity of our borders, We have a lot of corruption by immigration officers at those borders. Our countries are unstable, so they don't have adequate legislative frameworks to combat corruption and other crimes. High unemployment, all those I had listed in the previous slide when I was talking about the corruption vulnerabilities, capacity constraints in law enforcement agencies, lack of political goodwill, and also lack of international and domestic coordination. So if you look at this supply chain for poaching, for example, you can see how well organized it is. And at every stage of this chain, the poacher, local organizer, etc., corruption, there is bending of the law, people looking at the other way, and they can only be willing to look the other way if some money is paid. So very well organized syndicates. So as I said, I won't give case studies, but if you look at this report by the Egmont Group on the red flag indicators, all of these indicators, we see them for example, in our public procurement contracts. One company always winning the largest tenders, a contract having such unreasonable specifications because it's tailored for one particular contractor. Bank accounts of public officials receiving huge amounts. And if you look at the checks, they are probably issued by construction companies and legal entities receiving very highly complex government contracts, which they have no capacity to deal with, but they've been awarded that contract. And these are some of the red flag indicators for politically and publicly exposed persons, or PEPs. You know, that the banks will report seeing the huge amounts coming into their accounts. They can even be found with large amounts of funds in different currencies. A stated source of wealth of funds is inconsistent with the money which is appearing or which is being deposited in the PEP's account. So what are the challenges as I conclude? For law enforcement, because at the end of the day, we may report corruption, but what is being done to stop it? So the slow pace of, for example, anti-money laundering investigations and even other investigations, because we normally say that the predicate offense should be prosecuted together with money laundering. Poor grasp of the law, insufficient evidence to convict. The investigations are very complex. They normally transcend transnational boundaries, lack of capacity, witness unavailability, conflicting roles. For example, issues around mutual legal assistance requests, lack of modern investigative tools, for example, to do the financial intelligence analysis, very key. How do you go through the audit trail to see how the money arrived in that account and left it? High public expectations, of course, people expect a lot. And this is a report by ISAMLAG, which is the regional anti-money laundering compliance body for this region. And this is what they noted about the challenges with corruption in this region. For example, lack of sufficient evidence is there, the bribery of officials, the lack of prosecution capacity, the unrealistically high standard of proof, witness credibility, death of crucial witnesses. These are very high stake and high profile cases. So witnesses will disappear, they'll be killed, etc. And then internal challenges, I had mentioned this in terms of the budget allocations. Officers are not adequately trained. Unexplained wealth, conflicts between unexplained wealth provisions in the legislation itself, and the presumption of innocence, and then corruption of the judiciary. So this slide says it all in terms of the tone at the top. You can see these pigs, what they're saying, how do we deal with these serious allegations? We deny, and claim it's corruption fighting back. And that was a committee that was actually, charged with the responsibility to investigate corruption cases. So what can we do? Law enforcement agencies should play a critical role. They play a critical role as stakeholders. They need to be conversant with the law. Prosecutors and law enforcement agencies then need to work together to ensure the effectiveness and efficiency. in the conduct of these investigations and the closure of cases, and also familiarize themselves with the law in other jurisdictions, because these crimes, corruption and the other crimes, normally transcend transnational and continental boundaries. Then, of course, governments should address the lack of capacity, resource, and even invest in modern investigative tools. We need to have effective witness protection programs to address witness unavailability. And law enforcement agencies then need to also coordinate closely to avoid conflicting roles. And then we should aim at prosecuting and convicting key corruption and financial crime suspects, because this will satisfy high public expectations. And then we also need not only to have the necessary legislation in place, but we need to also have the regulatory regimes to enforce it, including appropriate training programs. So tone at the top is critical. We cannot overemphasize that. And these are some of the demonstrations that have been there in different countries, and some of the headlines, the impact of corruption, what it does in terms of decimating entire economies.
Okay, so your 15 minutes now. Thank you.
Thank you, and good afternoon. I think that most of the issues and the concept have been taken up by previous speakers. So we take you to the outline of our presentation. Let me say we are assessing the challenges of the legal framework on unexplained wealth in Africa. We are looking at this from the perspective of Ghana, on Ghana as it is in other African countries. And we look at the introduction, we pose a research question, and we look at objectives out of the research question. We look at some key definitions or concepts that we've come across in this work. And then we look at the relevant legal environment on unexplained wealth in Ghana. And I will look at some analysis of the implications of the laws, and perhaps we'll do a conclusion and some takeaways here. Now, from the literature, and fortunately, we're happy that Professor Ryder is here with us. From the literature on the unexplained wealth and on economic crimes, it is obvious that these are offenses or financial crimes that is affecting the world and the financial system of the world. Now, we see unexplained wealth and financial crime. These are very twin problems. And from all the assessment analysis, you see these are emerging phenomena in Africa. And in fact, the definitions of the concepts seems to make them very controversial legal concepts. And so looking at it from the perspective of developing countries is very challenging. Now, in looking at this, despite the literature that has emerged especially in developed countries, you see that the fight against this twin problem must look at from internal dimensions, and that is what our work is looking at. Global perspectives on unexplained wealth as a form of financial economic crimes, like I said, are well captured. But from the vast literature that you find out outside Africa, you look at it that the consequential effects of winning the battle has not been explored adequately as far as the fight against unexplained wealth in Africa is concerned. And institutional and legal accountability has become the focus now worldwide in looking at unexplained wealth. And so if you look at the EU, for instance, they've adopted a strategy where their financial laws seems to suppress the financial crimes by enacting laws that have basis and justifications on increased regulatory responses to financial crisis. And Colonel has done a lot of work on that. So how did they do it? You see that the Corruption and Crime Commissions in these jurisdictions are established to identify and follow the trace of these individuals and corporations engaged in these sort of crimes and their modus operandi in order to arrest them and curtail their activities. Now, the situation of Ghana is that there are a lot of couple of laws that seems to be dealing with these financial crimes and money laundering and process of crime. And that is what we intend to look into and to see whether these laws are adequate and effective enough, as it is in other African countries, in dealing with the unexplained wealth. And that is our research question. We pose a question that despite the challenges of unexplained wealth and the Ghanaian jurisprudence with a lot of laws, is it enough to deal with this emerging phenomenon, especially when Ghana is now emerging as the African center of trade on the coming to force of the African Continental Free Trade Area? Do we have enough judicial, legal framework that can tackle this emerging phenomena on the African continent? So our objective is to investigate this framework that seems to be existing and assess the challenges that are inherent in them, and also to assess the institutional regime on these unexplained wealth and other financial crimes and the legal framework that Ghana has. So we did some conventional definitions about money laundering, and we know some explanations that are around money laundering. And so we will not want to bother you, but we're giving some explanations that other scholars have given or other jurisprudence has given on money laundering, including Ghana. Then we look at what unexplained wealth means. And according to the Criminal Property Confiscation Act of Canada, unexplained wealth is when a person's value of wealth is greater than the value of his lawfully acquired wealth. And other definitions have been given. So what is the Ghanaian perspective on unexplained wealth in terms of definition? Now, an authority who is the new special prosecutor, Advocate Kisi Ajabin, had this to say about unexplained wealth and his understanding of unexplained wealth. It says, if we are to trace unexplained wealth in proper context, I would say that if the person cannot, opinions should be criminalized. But if you can reasonably explain how you came by that, and you cannot reasonably explain the shortfall as to how your lawful income falls short of your wealth, then I will be asking you to question and calling on you. This is the explanation, understanding of the person who is leading the fight against all forms of crimes in Ghana in the new law of the Special Prosecutors Act in Ghana. This is an understanding of what unexplained wealth means in the Ghanaian perspective or context. So we summarize unexplained wealth to mean the value of a person's wealth and or minus the value of a person's lawful acquired wealth. Then we know that this person or the wealth of a person can be deemed as unexplained or otherwise. Now, we also try to give a conceptual understanding of financial crime, and which is also sometimes called economic crime or illicit finance, and we want to. So what are some of the known or the means of unlawful acquisition of wealth or unexplained wealth? Trafficking in illicit drug or substances, corruption, bribery, money laundering, terrorism financing, thefts or fraud, blackmail or extortion, collusion or kickbacks, tax evasion, insider dealing or trading. Here we are talking about competition law and the inefficiencies in the competition and antitrust arena, market abuse and manipulation of the market. So what is the Ghanaian situation? Now, does Ghana have a specific law on unexplained wealth? And we want to refer to two important persons in Ghana and their position on unexplained wealth. First is Mr. Martin Amidu, who was a former Attorney General and the first special prosecutor who was appointed in 2009 and unfortunately resigned because of certain influences and challenges of that office. And that's what he just said last year. And we must mention that almost all the laws that deals with financial crimes in Ghana predate 2021. So any other thought that comes and gives a position outside the already known laws tells you or leads you into a certain conclusion. And that's what he says. A new Ghanaian law modeled after the UK's Unexplained Word Order could correct the defects in our current laws. Instead of relying on citizens to report omission to SHRAJ, SHRAJ is a Commission on Human Rights and Administrative Justice in Ghana. A Ghanaian UWO law would place the burden on law officials and private individuals to explain the sources of their wealth. Failure to do so would lead to a prosecution to prove their assets were acquired using legitimate source of wealth. These measures would complement Ghana's existing asset disclosure regime, which is difficult to enforce. And then the minority leader in parliament, just in the same year, also made this outstanding statement. There are still major legislative gaps. I sincerely believe that Ghana should pass a new law on criminal unexplained wealth as part of our collective quest to deal with white-collar criminality, craft, and economic crime. So this statement alone led us to the very conclusion that Ghana, as we speak now, despite all the legends of law, do not have a legislation specific to deal with unexplained wealth, especially coming from these two important legislators and former Attorney General. Now, so we look at the current relevant legal environment that seem or come closer to having certain provision or made specifically to do with financial crimes, and some other instance, people think that these laws must be able to deal with unexplained wealth. Now, the Constitution of Ghana comes to mind, which is the highest of the laws of Ghana. Then we have the Public Financial Management Act, and we have a specific Anti-Money Laundering Act, which was passed about 2 years ago. And then we also have the Commission on Human Rights and Administrative Justice Act, which we would emphasize, and the Whistleblowers Act. We have the Economic and Organized Crime Act, Act 804. Then most importantly, we have the Office of the Special Prosecutor Act, which I just mentioned. We also have the Criminal and Other Offences Procedure Act of 1960, Act 29. We also have the Right to Information Act and the Companies Act. So these are legislative instruments, among others, that one would look at and be sure that Ghanaian laws have the capacity, the adequacy to deal with unexplained wealth. And we'll see whether that has happened. Already I've mentioned the position by this, the former legislature, and then also the Attorney General on unexplained wealth. So in the 1992 Constitution, you find these various provisions, and that seems to deal with financial issues and how crimes on finance and management of finance should be done, especially on the asset declaration for public officers, Article 284, which requires all public officers to declare the assets on assumption of power and also after leaving power. Unfortunately, this provision is being abused for lack of transparency, because when a public officer declares his asset, that asset declaration is not known to the public. It's not open until an issue happens in future and the court orders for it to be open. So there are a lot of talks about it in Ghana as we speak, and people think that when we're able to fine-tune that provision and make a specific act, we'll be able to make effort in the fight against financial crimes and unexplained wealth. Now, the Commission on Human Rights and Administrative Justice is a very, very important body in Ghana, which has a constitutional provision and backed by constitution and by law. And its threefold mandates are the human rights mandates, which will not part of discussion, administrative justice, but what we are concerned with is the anti-corruption mandate of that agency. And over the years, that anti-corruption mandate has been manifested in various cases, before that body, in order to make sure allegations of crimes and corruptions are investigated and also dealt with. One of such case is what you call the Apia, Ampofo, and Shraj case, which was reported in the Ghana Supreme Court law report. And in this case, the commission, after assessing the fact, found that, and this was also, affirmed by the court, that the accused, had given $96,500 to a contractor, received as a gift from a contractor in order to facilitate a national project for that contractor from UK. And the court and the Shraj found that because they found that the source of the payment was from UK, and that the timing of the payment was to facilitate that contract. And they continued, the continued denial of the accused, that he did not, the respondents were also not tenable with the commission. And there was a lack of transparency in the payment of the money, which was lodged secretly in account that was known to the accused and the contractor. And so they were found culpable of the law. But the challenge of this commission in Ghana is that, first, it does not have a mandate to investigate or initiate an investigation on its own, except by a complainant of an individual or of a public institution. And therefore, the commission does not or cannot just be looking around and nosing around to find people who are involved in all manner of crimes, financial crimes, except when it has been, called upon by an individual. Now, currently there is a case which we call the ABAJ case, which is prominent. The court, the Shraj has dealt with, and its judgment.
I apologize. I'll have to ask you to round up now, please. Thank you.
All right. So, if you look through, having gone through all the legal framework in Ghana, we found out that despite the number of laws that we have, the challenge is that the provisions of this legal framework does not give the institutions that are mandated to run these laws the powers and to actually effectuate the laws, and gives a lot of vacuum, a lot of prosecutorial vacuum to the laws. And therefore, we made a conclusion that despite all these challenges, Ghana can make a headway by strengthening the legal and legal architecture of the financial crimes by way of a mirror of this African situation, and that Ghana should also criminalize unexplained wealth as an imposition of criminal law because of the existing legislative legal lack of legislative competence. And also, finally, we suggest that a single legal framework for anti-fraud rules, on unexplained wealth will be imperative and demanded. So if I have no other time, we'll conclude here and expect the follow-ups from.
Thank you so very much. I will not abuse Chair's privilege at this stage. I do have a couple of questions, but I'll wait to the question and answer session. So thank you so much. If I can now invite Dr. Nwoke Chinwe Ekwelem and Henrietta Agbo to please join us. If you could please stop sharing your screen with us, Francis, that would be fantastic.
Well, thank you. Thank you.
Good afternoon. My name is Uche Chukwunoke. I am presenting on behalf of my colleagues, Chinwe Ekwelem and Henrietta Agbo. And this afternoon, our paper is on adoption and implementation of unexplained wealth orders in the Nigerian criminal justice system. By way of introduction, the importance of confiscating proceeds of crime has long been recognized as an effective tool in disrupting the activities of organized crime. The underlying reason is that profit or financial gain is the main motive for criminals to engage in criminal activities. This profit is used to fund lavish lifestyles as well as invest in future criminal activities. The strategy of hitting criminals where it hurts most, their pockets, is regarded as an effective strategy by law enforcement agents for organized crime. In this context, confiscation of criminal proceeds is embarked upon by many countries through conviction and non-conviction based confiscation mechanisms. Unexplained wealth refers to valuable assets belonging to officials or others in positions of power and influence that are clearly incommensurate with their publicly declared earnings or known business interests. The Australian Criminal Property Confiscation Act of 2000 states that a person has unexplained wealth if the value of their wealth is greater than the value of their lawfully acquired wealth. The value of a person's wealth is the amount equal to the sum of the values of all the items of property and all the services, advantages, and benefits that together constitute the person's wealth. Unexplained wealth law requires a person who lives beyond their apparent means to justify the legitimacy of their financial circumstances. Unexplained wealth law seeks to deter crime, particularly organized crime, by reducing the profitability of illegal activities. Now, the topic is on unexplained wealth orders. So we have also deemed it necessary to understand what unexplained wealth order is. And we've said that it's a relatively recent development in confiscation and for future jurisprudence that target the proceeds derived from criminal activities. They are designed to further strengthen the fight against organized crime by enhancing the powers of the state in depriving criminal enterprise of their illicit wealth, particularly those individuals for whom insufficient evidence exists for criminal conviction. Like traditional in personam and in rem forfeiture, their primary objective is to deprive criminals from acquiring or benefiting from unlawful activities. However, by using unexplained wealth orders, the state does not have to first prove a criminal charge, as is the case with conviction-based forfeiture. Likewise, the state does not have to first prove that the property in question is the instrument of proceeds of crime, as is generally the case in rem asset forfeiture. UWO laws differ from traditional forfeiture laws in another important respect. They shift the burden of proof to the property owner, who must prove a legitimate source for his wealth, and the forfeiture proceeding is instituted against the person rather than against the property. These seemingly radical features of unexplained wealth order laws, that is no proof of the property being connected to a crime and a reversed burden of proof, have in practice been tempered by courts, prosecutors, and police, but still are a powerful and controversial tool for seizing assets where traditional methods likely would have been ineffective. Now we get to unexplained wealth in Nigeria. Despite the efforts of many administrations to fight corruption, Nigeria remains one of the countries that constantly top the world's corruption rankings. Transparency International reviewed that Nigeria came 146th in the rank of 2019 Transparency International's Corruption Perception Index. In the index released by the Civil Society Legislative Advocacy Center, it was revealed that Nigeria scored 26 out of 100 points in the 2019 Corruption Perception Index. The country slipped further down 3 points in the 2020 index, which is the lowest point of corruption index since 2013. In Nigeria, corruption includes various financial crimes, including bribery, which involves taking funds from public coffers and putting them into private pockets. After being laundered within the country or abroad through offshore companies, for example, those stolen funds resurface as unexplained wealth. Now, in terms of regulation, there are instruments and institutions regulating unexplained wealth at least before 2022. We had the 1999 Constitution, the Nigerian Financial Intelligence Unit, which established the FI, that's the Act of 2018, which established the unit. Then the Code of Conduct Bureau and Tribunal Act 1991, which set up the CCB, which is the Code of Conduct Bureau. The Economic and Financial Crime EFCC Act, which created the EFCC. The Independent Corrupt Practices and Other Related Offences Act, which created the ICPC. And then the Money Laundering Prohibition Act 2012, which has now been amended by the Money Laundering Prevention and Prohibition Act 2022. And you also have the Recovery of Public Property Special Provision Act 1984, and then the Advanced Fee Fraud Act. Now, under Section 44(1) of the 1999 Constitution, a person's fundamental right to property is assured. However, Section 44(2)(b) of the same Constitution establishes, by reference to subsection 2, that the fundamental right to property in subsection 1 will not operate to divest, or undermine, or prevent any legislation intended to impose penalties, impose forfeiture for breach of any law, codified civil or criminal laws, whether under civil process or after conviction for an offense. Now, under section 28 and 29 of the EFCC Act, we have what is described as forfeiture upon conviction or criminal forfeiture. So, but this has to do with the criminal proceeding. Now, under section 17 of the Advanced Fee Fraud Act, there are 3 circumstances where non-conviction-based forfeiture can occur. A, where there is an unclaimed property coming into the provision of the EFCC. B, unclaimed property found by officer of the EFCC to be in possession of another person, body, corporate, or financial institution. And then where properties in the possession of any person, body, corporate, and financial institution is reasonably suspected to be process of some unlawful activity under the Advanced Fee Fraud Act, Money Laundering Act, EFCC Act, and any other law enforceable by the Commission. Now, before 2022, there were cases decided by the Nigerian courts regarding forfeiture of assets. In FRN and Nwigwe, or against Nwigwe, the Court of Appeal Division in Lagos State unanimously struck down the relevant sections, that is sections 28 and 29 of the EFCC Act, as unconstitutional, despite the clear justificatory grounds presented by the law. In 2012, the Court of Appeal in Akimbola against Chairman EFCC realized this error in Federal Republic of Nigeria against Nwigwe and proceeded upon an exhaustive scrutiny of the Advanced Fee Fraud Act to set aside the earlier case. Now, many other cases, including Felimont Enterprise against Chairman EFCC, Federal Republic of Nigeria against Ikedinwa, Esai Dangaba against Federal Republic, have all upheld the validity of the Advanced Fee Fraud Act provision, that is section 17, which authorizes the state to confiscate property which is suspects to have been a proceed of illegality. Now, in Patience Jonathan against Federal Republic of Nigeria, the trial court made forfeiture order as money in Mrs. Jonathan's account were seen as proceeds of some unspecified unlawful activity. This decision was affirmed by the Court of Appeal, and this is a 2018 decision of the Court of Appeal. Now, in May 2022, precisely last month, the Nigerian president signed into law the Process of Crime, Recovery and Management Bill 2022. Now, this act, which is very new, in fact, it came into operation after the first draft of this conference paper was written. It makes provision for the seizure, confiscation, forfeiture, and management of properties derived from unlawful activity. Now, under Section 1 of the Act, there is an effective legal and institutional framework for the recovery and management of the process of crime, benefits derived therein, instrumentality of unlawful activities, and unclaimed properties reasonably suspected to be process of crime. Now, if you notice in the slides, you see that we underline the instrumentality of unlawful activities. This means it's no longer about criminal proceedings alone. Once there is an unlawful activity, whether criminal or not, then there is a framework for the recovery and management of the proceeds of such an unlawful activity. Now, section 1, paragraph B also made provisions for the restraint, seizure, confiscation, and forfeiture of property derived from unlawful activities and any instrumentalities used or intended to be used in the commission of such unlawful activities. And then paragraph C, make provisions for non-conviction-based procedure for the recovery of proceeds of crime. D, strengthens the criminal confiscation procedure by ensuring that the total benefit from a person's criminal activity is calculated and equivalent amount where recoverable is confiscated on behalf of the federal government. So in these provisions, there is a kind of tilt towards confiscating proceeds of crime, even when there is no criminal proceeding. And so the argument is that there is now a movement towards unexplained wealth others in Nigeria, because through this particular law, the requirement that the state can confiscate even when there is no criminal proceeding, as we have in the unexplained wealth other laws, has come to the fore. And then under section 2 of the Act, it tells us that the provisions of the Act will apply to detection, identification, investigation, and recovery of realizable assets and the processes and instrumentalities of unlawful activity by relevant organizations. And then confiscation orders to recover a sum equivalent to the amount a convicted person has acquired from the offenses charged and related offenses, including accrued benefits. Now we move to part 4 of that particular Act, which deals with non-conviction-based recovery of the proceeds of crime. Section 7 applies to the recovery and forfeiture of proceeds of crime, instrumentality of unlawful activity, abandoned properties or unclaimed properties reasonably suspected to be proceeds of unlawful activity without conviction. Without conviction. So we now have a non-conviction-based recovery of proceeds of crime, re-emphasized. We had that in section 17 of the Advanced Swift Fraud Act, but this particular act has also re-emphasized that capacity of the state to recover without conviction. Now under section 8, sub 1, proceedings under the part shall be civil proceedings, and that is very, very important. The standard of proof required in proceedings under this part shall be on a balance of probabilities. The rules of practice relating to hearsay evidence given in furtherance of the proceedings is admissible. So it is therefore arguable that unexplained wealth order law, a relatively recent development in confiscation and forfeiture jurisprudence, which target the proceeds derived from criminal activities, is now present in Nigeria. The Proceeds of Crime Recovery and Management Act 2022 now has provisions which allow for the making of unexplained wealth orders. Because that is the argument we are making, that based on the provisions of this particular act, the Nigerian state is now able to use unexplained wealth orders to recover wealth they suspect to have been reasonably acquired through illegal means. It is hoped that the Nigerian state will rely on these provisions to confiscate unexplained wealth and help reduce, or at least, if not eliminate, criminal activities in the country. Thank you.
Actually, right on time. Thank you so much. So if we welcome our final speaker, which is Dr. Mukuru. He's going to talk about public procurement and unexplained wealth in Nigeria and ecosystem approach. So if I could ask you to please stop sharing your screen, and if I can invite Dr. Mukuru on, please. Dr. Mukuru?
Yep.
You are here? Fantastic.
I'm here. I'm trying to share my screen.
Okay, so one of my team members is actually sharing the screen for you. Is that okay?
It's okay.
Okay, fantastic. So your 15 minutes starts now. Thank you.
Okay, thank you very much. So my name is Benjamin Mukoro. I work with the Global Center for Law, Business and Economy in Abuja, Nigeria. So the aim of our presentation is to do a simple thing, a very simple thing, is to help focus attention on the right group of people when dealing with unexplained wealth in Nigeria. And that particular group is those persons that are involved in the procurement system in Nigeria, the public procurement system. Can I have the next slide, please? Can I have the next slide? Okay. So next slide. There is no definition of unexplained wealth in Nigeria, so we made a trip to Australia, just like Dr. Wonke, to borrow a definition. So if we could have slide 6, please. Slide 6. Slide 6, yes. Yes, yeah. Please, just the last slide before this one. Yes. Okay, so much of unexplained wealth in Nigeria is actually results from public procurement crime, and it is estimated that about 60% of corrupt wealth emanates from procurement crime. So I don't know if I can get the next slide. There's a slide I really need. Yes, this is the slide I'm looking for. So the cost of contract project in Nigeria is about 35% higher than what obtains in other West African countries. And the World Bank Country Assessment Survey conducted in the year 2000 suggested that 60 naira out of every 100 naira spent by the government was lost to procurement fraud. This survey actually inspired the Public Procurement Act of 2007. The Independent Corrupt Practices Commission also announced in 2016 that 60% of corruption cases in Nigeria were procurement related. So this justifies our focus on procurement crime as a means of dealing with unexplained wealth in Nigeria, because a lot of unexplained wealth that might be found in real property investments, investments overseas actually originate from the procurement process. Next slide, please. Yes, so we have different types of procurement crime: inflation of prices, unlawful influence, bribery, bid rigging, splitting of tenders, forgery, and obstruction of investigation of procurement records. These are provided for in Section 58, Sub 4 of the Public Procurement Act. And the Public Procurement Act also sets up a regulatory agency, the Bureau of Public Procurement, to regulate the procurement processes in Nigeria in order to prevent procurement crime. But as we'll see in our presentation, there are certain structural loopholes that are embedded in the procurement system that makes the system vulnerable to abuse. If you could go to the next slide, please. The next slide, please. Yeah. So the next one. So we have processes like that require procurements to be done through bidding processes, and there are approving authorities for bids, the parastatal tender boards and the ministerial tender boards. And you have the National Council of Public Procurement as the approving body for thresholds, for financial monetary thresholds for different kinds of procurement. For instance, there are procurements that require the approval of the accounting officers in the ministries, which is the permanent secretary. And there are procurements that require the approval of the director generals in the agencies, procuring agencies. So the National Council on Public Procurement actually sets these thresholds. And after setting the thresholds, the procuring entities are required to carry out the process of procurement in accordance with rules that are laid down in the Public Procurement Act, which include advertisements, external observers from professional bodies, a regulated process for bid evaluation, compulsory debriefing of bid losers, communication of rebidding results to the minister and to the bid winners, execution of agreements, and publication of awards. Next slide, please. So we came up with a model just to show the loopholes in the public procurement landscape. It's a model that could still be developed further, but we just want to show how the relationship between the different players in the procurement landscape looks like. Then in the green box, you have the elected members of the executive arm of government. And then in the box opposite the green box, you have the legislators. Now the legislators have there's a relationship they have with the executive arm of government. They have an oversight function over the ministries, the departments, and the agencies. But then the same legislators also propose constituency projects to be executed, to be awarded by the executive arm of government. And then the ministries, departments, and agencies have a regulatory relationship with the regulatory agencies like the Bureau of Public Procurement. And then you have, in between them, you have the contractors and then the suppliers. There's a theme here, which is the main point we're trying to bring. There's a lot of membership overlap between these groups. Among the executives, you have members of the executives that are also on the boards of some of the regulatory agencies. Now, these regulatory agencies are supposed to supervise contracts awarded by ministries, departments, and agencies, which are directly under the executive arm of government. So that raises the issue of independence of regulatory bodies in the procurement process, which is really the main point we're trying to make here. If you look at the blue box here for the regulatory agencies, you see an icon representing membership overlap that has a green color. That tells you that there are some members of the executive that are also players in the regulatory field. And then you have a brown icon, which tells you that there are ministries, departments, and members of MDAs that are part of the regulatory agencies, because according to the laws, some of those officials could be seconded to these regulatory agencies. And all these actually create a lot of problem, a lot of loopholes in regulating a sector that is the primary source of unexplained wealth in Nigeria, and I dare to say in most parts of the global south. So can we go to the next slide? This actually talks about this slide talks about the constitution of the National Council on Public Procurement, who the members are, the Minister of Finance, the Attorney General, the Secretary to the Government of the Federation, who happens to be the one that awards constituency projects that are proposed by legislators, the head of service of the Federation, the economic advisor, and so on. You can go to the next slide, please. And then the Federal Executive Council, in absence of the National Council of Procurement, this is an even more dangerous one, acts as a procurement panel. Because whenever the Council of Public Procurement is not inaugurated, the Federal Executive Council acts as a procurement panel. And this definitely raises a lot of issues with the independence of the regulators. Next slide, please. So we look at the constitution of the Bureau of Public Procurement in this slide. It says the Director General shall be appointed by the President on the recommendation of the Council. We've already seen how the Council overlaps with the regulatory agencies and all that. So this is just to show that the regulatory structural loopholes are embedded not just in practice, but in the very laws that regulate procurement in Nigeria. Next slide, please. So we propose very simple reforms. We propose restructuring to create truly independent regulatory bodies. We propose restructuring to create truly independent anti-corruption bodies. Now, I didn't mention a lot of the statutes, the regulations that, the legislation that relates to prosecution of procurement crime and unexplained wealth, because a lot of, I envisage that a lot of speakers will speak on that. There are actually other laws that talk about that talk about prosecution of crimes that relate to procurement, and without expressly providing for explained wealth orders, the Constitution in section 36, subsection 5, provides for the shifting of the burden of proof, which is a major component of unexplained wealth orders, and that is already embedded in the Money Laundering Act. And the next recommendation we have is implementation of open contracting data standards, and of course, the implementation of the unexplained wealth order, as we have it, as we have components of it in different legislation, and better still, it should be implemented as a specific provision in a dedicated statute. Thank you.
Fantastic. Okay, so we'll go straight into the question and answer session, I think. And we've had some amazing presentations today. Just before we do that, I do want to apologize. I realize that we are running significantly or drastically behind time, but we will try and get to some of these questions. So the first one that I've had some emailed and some sent to me privately. The first one we have is for the speakers on Ghana. And the first question is, what must Ghana do to strengthen its legal and legislative architecture to tackle its illicit financial flow and unexplained wealth? So Francis, I don't know if you want to share some insight into that, please.
Yeah, thank you for the question. Now, what Ghana needs to do, as we suggest, is to have specific regulations and institutional framework that deals with the phenomenon of unexplained wealth. At the moment, what Ghana has is some selected or some isolated legislations that takes on certain aspect of financial crime under different legislative instruments. And so we find out that this does not give even the powers of the prosecutorial powers to the Attorney General himself to prosecute offenses and to get effective convictions. So the only way is also to have these laws and also to finance these institutions that have been given the powers, state support, because we find out that the office of the special prosecutor, which is touted as the most, to say the most comprehensive legal framework, is having the challenge of finance, public finance, and also political influences, because it was thought that this was going to be an institution that was going to have the independence to prosecute people involved in financial crimes. But it is not having that leeway. And that led to the resignation of the first special prosecutor, just a year ago, after taking office for just a year, a person that all Ghanaians described as citizen vigilante and has records of fighting corruption, even in his own government. Because of the political influences, he could not survive in that office. And there is a new special prosecutor who is facing the same challenges of finance and public support. So I think that having had a specific legal architecture for the fight against unexplained wealth will be the way forward, as suggested by the minority leader, and then also the former special prosecutor, and then the AG. So that's, I think, will be a way forward for Ghana.
Fantastic, thank you so much. Dr. Ilaria Zavoli, I have a question here for you. Would the UK benefit from some sort of financial intelligence and/or reporting system by real estate companies for tracking unexplained wealth and deter money laundering?
That's a very interesting and good question, I would say. In theory, there are already in place some practices and strategies in this sense, because in theory, again, the suspicious activity reports system that applies to all sectors, not just the real estate one, should be used in this sense. So in theory, this should be the way in which real estate agents, for instance, or lawyers that are involved in property transactions flagged up dodgy transactions or problematic transactions to, for instance, the NCA. The problem, though, is that as we've seen in very recent reports from NCA and HMRC, we have huge problems in terms of the number of SARS that are filed, as I was also saying during my presentation, and the quality of these SARS, because the reports are actually very poor in quality. They don't really provide enough detail, enough information about the transaction. And also, most of the times, these SARS are actually filed just to provide a defense to real estate agents and anyone else involved in a property transaction. Because if you file a SAR, you will get automatically a defense if something goes wrong, if the transaction is actually then found out as being indeed money laundering. So the problem is, how can we make sure that the SARS that are filed are properly done, they are high quality, but also they are actually the ones that need to be done. And it's not just like overloading the system that is already incredibly overloaded with not enough personnel and resources to go through all of the SARS. And so making sure that we have a sort of filtering system at the very beginning, where not everyone, simply for the sake of being on the safe side and protect themselves with the defense, will file a SAR. So there is something already in place. Is it working? As usual, I think we have a lot of problems and challenges. I mean, I don't want to obviously always talk badly about the UK anti-money laundering regime, but there are various issues that are unfortunately affecting the regime, and they're making, I mean, they're creating additional issues and problems for everyone involved, really, from enforcement agencies to practitioners that are trying to do their job as best as possible, but they are really hindered in their daily practice, because also, what is the incentive of doing this?
This is another question, yes. Just a follow-up question that I might ask. So with the enactment of the Economic Crime Act, do you think that this will really help the process, or is this something that we need to wait and see?
Good question, Paula. We'll see, in the sense that, as Nicholas was also saying this morning, right? So there are, again, as usual, a lot of expectations out of, new legislation implemented and the new act. The problem, so the new act is sort of trying to tackle some of the challenges and issues that we saw so far with the UVL system, but also with the sanction system, but also introducing, as we were saying, the ultimate beneficial ownership register, right, for property and land that was missing. Is one of the three now that is at the moment present in the UK, but that was missing. But then the problem is not in terms, and as Nicholas was saying, it's not the problem really of how much legislation do we have in place. There is actually a lot already that has been done, but it's how well, to what extent we're actually implementing this efficiently, effectively. How much resources do we have to allocate to this? And also, it's not just a question of the government imposing, with a top-down approach, legislation, obligations, so regulations on different sectors and practitioners, but it's also, what about the responsibility? So shared responsibility is something that I'm really advocating for since like some years now. What about the responsibility of those from the sectors that are working on a daily basis in their practice? They might know much better than the government or what are the challenges that they face in their daily practice when they might be, targeted by criminals, by money launderers. That's the problem. So the act itself sounds good, sounds brilliant on paper. The problem is how we will implement that, but also how well then this will be fitting within the practice of people that they have to, at the end of the day, they have to pay their expenses, they have to have an income, they have to have some sort of fees and so let's say advantages in doing their businesses, right? So they can't be hindered in that, and at the same time we ask them to be the gatekeepers of their sectors and fight money launderers. So there is this constant tension between expectations, idealism, I would say, of the government, imposing again sanctions and obligations top down, and what is actually the reality of the sectors. And when I was doing my interviews, this was a widespread criticism, I can say.
Thank you so much. I have a question for Mercy. Mercy, what policy reforms focus do you think is more important to tackle AML in East Africa? Which African countries need special attention? Is Mercy here with us?
Yes, I'm sorry, I've just come back. I had dropped off to attend to another call.
Okay.
Could you please repeat the question, please?
Sure. What policy reform focus do you think is more important to tackle AML FT in East Africa? Which African countries require more special attention?
Okay, in terms of policy reform, okay, I would say, as I mentioned, what we need in East Africa really is commitment to the cause of actively fighting AML and all the other, money laundering and all the other predicate offenses. The laws are more or less in place. In fact, if you look at the mutual evaluation reports for all the countries apart from maybe Burundi, and even Southern Sudan, we all have the laws in place. The issue now is implementing them. I think the only serious gap I would say is there in a number of the countries, because I did a review of the situation obtaining in most of the East African countries and a number of West African countries and Southern African countries as well, is the enactment or implementation of beneficial ownership regulations. Some countries actually don't even have a definition of beneficial ownership. Others do, but they haven't put the regulations in place. But in terms of the country that needs most focus, so that's doing badly, the two countries of Southern Sudan and Burundi. Burundi, both of them are still observers, and they're not full members of SAMLAG. They have serious deficiencies, particularly Burundi. So those two countries, again, will need to refocus their efforts, not only on legislative reform, but also, even basically implementation. Actually, for those two countries, legislative reform is key. For the other countries, really, it's implementing what they already have in place. And as I said, tone at the top is critical.
Fantastic. Thank you so much. I have a question here for Amina. Maybe I should take this moment to say I'm really proud of you, Amina. Amina used to be my student many years ago. So fantastic presentation. So Amina, could the absence of a robust system in public accountability on the Kuwait royal family hinder the fight for unexplained wealth in Kuwait?
So basically, the members of parliament in the state of Kuwait is usually members of the royal family. So when it comes to that, they usually abuse their roles as members of parliament. And can you rephrase your question, please?
Sure. Could the absence of a robust system of public accountability on the Kuwait royal family hinder the fight for unexplained wealth in Kuwait?
Yes, so yes, it can. Obviously, once we tackle the whole area of corruption, we try to prevent and use preventive measures. Yes, that can be tackled, yes.
Fantastic, thank you. We have a question here for Dr. Mwoke. In light of Nigeria's CPI, what are the issues associated with the enforcement of legislation on unexplained wealth in Nigeria?
Okay, thank you very much for the question. I think the issue of enforcement more or less is something that goes beyond unexplained wealth. Nigerian problem has never been a dearth of laws or legislation, or rather that of enforcement. And then I think the problem more basically is a problem of will, in the sense that policymakers and those who are saddled with the responsibility of making the laws appear not to have the will to bring them into effect. Maybe because they themselves are part of the problem. Because you cannot expect a person who is part of a problem to solve that particular problem. It's going to be difficult. So I think that is basically the problem. It is your will. We have the laws. This one has come in now, just a couple of weeks old. But you will still find out that the problem will be in its implementation, its enforcement, because those who are saddled with enforcing the law are also corrupt themselves. So it's a kind of vicious circle. That is what we've come to see in Nigeria.
Fantastic. Thank you so much. I have one more question. So I have 2 or 3 questions, but I'm just looking at the time and I don't want to keep everyone for too long. I'm Clancy. I hope I've not murdered your name, and I really apologize if I have. So I'm going to call you Miss Clancy so that you can correct me. What are the possible regulatory / legislative reforms needed in the UK to strengthen UWOs as a powerful tool in tackling illicit cash flows? Yes.
Thanks, Fola. My first name is pronounced Anya, which is impossible for anyone who's not Irish, so don't worry.
Noted. Thank you so much.
In terms of what can be done structurally to include unexplained wealth orders, in some ways, I think the problem isn't so much that unexplained wealth orders can be improved, although a lot more enforcement, a lot more political will and resources could be thrown behind their enforcement. But I think more fundamentally, unexplained wealth orders are trotted out constantly as evidence that the UK government is doing something meaningful about corrupt wealth and dirty money flooding through London. But we know that in practice, it's not actually being enforced at all. I think broader, more fundamental structural change is required around transparency in our companies, transparency in how trusts are managed, verification of the identities of people who beneficially own assets in the UK, and a lot more enforcement. And this points to something that a number of the speakers have said throughout today, further enforcement and oversight of the people who facilitate illicit wealth to flood the UK. So solicitors, estate agents, bankers, accountants, etc. There seems to be very, very little consequence for them in circumstances where they, their clients subsequently have been found to have been dealing with illicitly acquired assets in the UK. So there are a multi-pronged anti-corruption approach is needed, and it's not sufficient just to say, oh, we are strengthening the ability to use unexplained wealth orders all the time. I know that doesn't directly answer the question, but I think it kind of gives more context around the use of unexplained wealth orders.
Fantastic, thank you so much. I have a question here for Ilaria. With regards to the ease of obtaining evidence overseas, are there legal considerations under which suspect evidence obtained overseas can be rejected by UK courts in UWO proceedings?
Yeah, I think that this was also something that was considered in the 4 cases actually that we had so far in the UK. So the question of, so first of all, just to clarify, obviously, as we said so far, the UVO's system is not about criminal proceedings. So first of all, there's not the same, obviously, standards of proof, so it's not beyond reasonable doubt, but also it's just an investigative tool. So it's just something that comes at the very beginning of a possible proceeding later on. So it could be that followed by a civil recovery recovery order. So it's something that has nothing to do with a proper criminal proceeding or suspicious that someone has committed a crime. This is an important consideration, because then the evidence that is gathered when the order is made, so is asked to the person to actually explain the source of this wealth, cannot be used in subsequent criminal proceedings. Interestingly, though, and again, the Hussein case is something that we should pay more attention to. In the Hussein case, Mr. Hussein that was actually responding and actually representing himself without a lawyer, so that's also interesting. He flooded MCA with folders full of evidence about his wealth, but he actually gave away additional evidence of his implications with criminal organizations in the Leeds and Bradford area. So it was actually detrimental for him to provide evidence. So the problem of overseas evidence instead is bigger and it's more complicated, because this pertains usually PEPs, so rather than criminal organized structures. So we then have the necessity to have cooperation from, for instance, foreign national authorities. And when that's not possible, we need to rely upon what the person is responding to the UVO is saying. There might be also issues in terms of the type of, what are the, again, like the basis upon which the MCA, for instance, is asking for the order. There was one of the cases was unsuccessful. There's a Baker case, because there were high suspicions that the source of wealth wasn't really like clear, wasn't really like, legitimate and licit. But then the judge actually said dismiss this, because he said, well, it's not actually proven, even on a balance of probabilities, that this is actually the case. So there are good explanations of the fact that these people are the owner of the properties and they have not necessarily connection with the PEPs, even if it was a former, like husband and it is the father of the son. But it's just like a matter of, we can't simply say that because you are wealthy, you come from a specific country, from a specific jurisdiction, it might be already problematic. That means automatically that there is money laundering, that you are actually trying to launder the proceeds of crime. So this is a very thin line, I would say, a fine distinction that though proved particularly problematic for MCA. And then as a result, as I said today in my presentation, the case was lost, but also there was a request of 1.5 million pounds in compensation. That's a huge amount of money, and obviously took everything back. So that's why also we didn't have, I guess, additional UVOs afterwards.
Fantastic, thank you so much. I have a question for Benjamin. Are there legal strategies to effectively address loopholes in procurement crimes in Nigeria?
Basically, the most effective legal strategy would be to restructure some of the relationships between the institutions involved in procurement. That would be the most effective legal strategy. For now, what we have is basically the anti-corruption legislation, which we've talked about, Dr. Wonke talked about a lot. So apart from that, we don't have any other thing apart from these laws. So with these laws, there are still procurement crimes. So it tells us that we need to do something more than just having these laws. We need to restructure the way we do procurement.
Fantastic, thank you. And I might just add on, since everybody's abusing chair's privilege today, I guess I might just add on, and this is a question to Francis, to Dr. Nwoke, and also to Benjamin. It seems that Ghana and Nigeria have all these many laws. Is it that the problem is enforcement of these laws? Is it that there is an unwillingness, if you like, to really tackle this issue of unexplained wealth? And I guess the other part of that question also would be, if we were to introduce UWOs into Nigeria or into Africa, more widely speaking, is this something that would work? What are some of the challenges that you think we might experience? So maybe I can go to Dr. Nwoke first, then to Francis, then to Benjamin.
Okay, thank you very much. Like I said before, when it comes to enforcement, the problem is lack of will on the part of those who are meant to enforce these laws. The problem of Nigeria has never been laws. We have more than enough, but we keep churning them out without really enforcing them. And like I said before, it's like a vicious circle, because you look at it objectively. The man you expect to enforce these unexplained unexplained wealth of some other person has his own unexplained wealth somewhere, and so it will be almost impossible for him to begin to pursue the other person who is in the same position as himself. And that creates a big problem. The system needs to be overhauled so that the right persons can be put in the right positions. It's an institutional problem. And until the institution is sanitized, it is going to be problematic. And so the idea of unexplained wealth orders and then their enforceability and effectiveness in a place like Nigeria will always be difficult. But if the right persons are there, I think there is no reason why it shouldn't work. But because the right persons are not there, what the law enforcement, you talk about EFCC, for instance, and then enforcement. They grab a person, say they have arrested the person, and the next thing you hear is they are asking for millions of naira from the same person they arrested, instead of going after the person. In fact, in Nigeria, the language is, where is our own share? Where is our own court? So even from those who are meant to implement, the moment they arrest, they ask you, where is our share from whatever it is you have acquired? And so from the unexplained wealth, they get part of it, which also becomes unexplained because it is not part of their salary. And so it's you see the vicious cycle continues. Thank you.
Fantastic, thank you. And Francis?
I'm standing in for Francis. This is Joyce.
Hello, Joyce.
Hello.
Hi, we can hear you. Go ahead.
Okay. I will go on the lines of the first, the one who just submitted now. Yes, the case is about unwillingness. It is part, and as Francis put forward before, the support from those who are supposed to, as in state support to the institutions that are set up, is very also lacking. So yes, as you said, unwillingness on the part of those who are supposed to make sure that the laws that are put that are out there are working. It is not there. So definitely the unwillingness is there. The state support too is not there. And as the first presenter mentioned, those who are supposed to implement, they are themselves also getting something out of it. And even DS2 is an unexplained wealth of which they have to be tackled. Thank you.
Thank you so much. And Benjamin, if you'd like to wrap up for us, thank you.
Yes, I think the unexplained wealth order would just be another order in the long list of orders we have in our legislation, provided for in our legislation. So if we are to move forward beyond what we have here now in place, we have to look at developing the political will to fight to prevent unexplained wealth, and then also make our institutions as independent as possible from the people performing, actually carrying out these crimes.
Fantastic. Thank you so much. So I think I will bring the session to an end now. I appreciate that we have run over substantially over time. I'd like to take this opportunity just to thank every single person for taking time out to join us today. We've had some very insightful presentations, and for me, it's been a real learning curve. I've just put in the chat Andrew's book. Andrew, I hope you won't mind. I've put the link for Andrew's book. It is open access. I've certainly found it very, very interesting, and I've learned quite a lot from it. So I've put it in the chat. Please do feel free to download and take a look in your own time. I think you'll find it really insightful. Again, to thank all of our presenters. So with that, I will bid you good day, good afternoon, good night. Thank you so much for joining us, and have a lovely afternoon.